So my Bluetooth headset's not compatible. I have to get a wired one. So until then, the recordings that I'm making, I'm not sure if the sound will be clear enough or loud enough, but I'll try my best to speak as loud as possible. So far we have discussed what law of tort is, definitions of tort. We have differentiated tort from contract. We have seen how tort and breach of contracts different. We have looked at the relation between tort and quasi contract, and then we have looked at difference between tort and crime. Okay, so this is what we have so far discussed. Okay, there's one more thing that we quite often distinguish. Okay, it's basically difference between tort and what did I say? Trust, law of trust. Okay, and equity generally. Okay, so as I told you, this is very simple difference, but I can't tell you guys specific differences between tort and trust as of yet because you do not know about the concept of trust. But just know that tort is different from obligations arising out of a tort is different from the one that arises out of a trust. Okay, so if you were in England, your trust would have been something that would have been created by the court of equity, court of chancery.
Could you start recording the session as well?
Sorry?
So could you start recording the session as well?
Yes, I've been recording. 1 minute 47 seconds elapsed. I'm not recording on this platform. I'm recording on photo booth, so don't worry. The problem with this is that when I complete recording, sometimes one of you also become proprietor of the recording, so I don't do that. So I record it on my own computer and then I upload. So don't worry about the recordings. So yes, tort is to be differentiated from trust. In India, you have Indian Trust Act, okay, that deals with laws relating to trust. So anything that related to trust in India would be dealt with by the Act itself. Whereas in case of tort, we do not have any codified law, as you guys already know. It is an outcome. It is a creation of common law courts in England, and we inherited the same system. So lots of decisions which of courts in England are also relevant for us. Okay. So you will see that when we discuss about lots of law of torts, okay, we will look at lots of English cases, okay, because they are important for us in understanding law of torts, okay. So today let's look at different elements of tort. So you know that tort is a civil wrong, okay, but not every civil wrong is a tort, okay. So there are certain specific elements of tort. Okay, so what are those? The first and most important element is a wrongful act. Okay, in tort there has to be a wrongful act. Okay. Now this wrongful act could be subject of both tort and crime. Okay, as you know, we have discussed that the same act can lead to both a tort as well as crime. But in tort we need a wrongful act. Okay, by the defendant. Okay. And that wrongful act, okay, I'm using the word act in a general sense, broad sense, okay. Now that wrongful act leads to certain legal damages, okay. So that legal damages has to be given to the plaintiff, okay. So wrongful act by the defendant leads to creation of this duty to pay legal damages to the plaintiff, okay. And the third important element is that the act must be of such a nature as to give rise to, legal remedy. So, so not every act, okay, only some act will be, okay, that we will see, okay. So legal remedy in the form of an action for damages. So if any right is violated of the sort that we discussed, it leads to creation of a form of action for damages, okay. So that's essentially what you have in case of tort. Okay, so let's break down the three elements that we have just discussed. Okay, the first element that we discussed is a wrongful act by the defendant. So what is considered as wrongful act? So if you remember, a wrongful act, I just told you that I'm using the word in a broad sense, okay? So it could be, when I say act, it could be an act, it could also be an omission, okay? So when I say act, you do something. When I say omission, you basically, you had a duty to do, but you didn't do it. So you wrongfully omitted, okay? So the first element here is wrongful act, okay? Now, not every act will be, subject to this, okay? Only wrongful act. So what is a wrongful act? Wrongful act is an act that invades a private right of a person. If you remember, we discussed the other day. It invades a private right, not a public right, not a public duty, okay, but a private right, okay? So some examples of that, okay? How can one harm you, okay? How can one, affect your private right, okay? So there are many different ways in which people can harm you. People can harm your body, okay? People can harm your body. People do not need to harm your body but still can hurt you. So for example, people can harm your reputation, okay? Your person essentially, okay? And then people can also, harm your property, okay? So in all these cases, okay, be it your physical body, be it your property or your reputation, in all these cases, there is a harm that has been done to you. And you had a private right with respect to all this, that you are not harmed in that. Okay, so for example, you have a right to a good reputation. Okay, so you have a right to a good reputation. So no one can harm your reputation without a proper cause, okay, without a proper justification for that. Okay, so yes, so that's a private right that you have, okay, a right to a good reputation. Then you have a right to your bodily safety, okay? You have a right to your bodily safety. I told you that tort is based on this principle of, thou shalt not, you shall not harm anyone, okay? So these are all harm to you, okay? So your bodily safety, someone, tries to assault you, okay? Someone punches you, so that compromises your bodily safety, okay? So you have a private right that your bodily safety is not interfered with. Not just safety, but you also have a freedom, you also have a right to freedom, okay? So no one can, arbitrarily confine you, okay, or restrain you from your, free right to free movement, okay? So that is also your private right. Then you have a right to property. I'm using the word property in a very broad sense because, property is a very complicated, issue that we will discuss later on in law, in first jurisprudence 2, or you don't have jurisprudence 2. I think you wouldn't even learn that subject anyway. But then you'll be taught in other subjects, hopefully. But anyway, so there is the third element is right to property. Okay, so someone cannot trespass your property or create nuisance, etc., etc. Okay, so if you have a private right with respect to all this, okay, so you see all these rights are in rem in nature. So others also, the general, people in general, okay, also have a legal duty to act or abstain with regard to your private rights. So for example, when it comes to trespass, others have a duty to abstain from interfering with your property, to abstain from hurting you, okay? So, this is what the first element of tort is, okay? There has to be a wrongful act. So when is an act wrongful? Not every act is. Those acts which affect or invade your private right, okay? And that's what leads to tort. The second important element is legal damage, okay? So this interference, this invasion of your private right will then lead to certain legal damage, okay? So when I say legal damage, so this is going to create some confusion for you. When I say legal damage, it does not commensurate, okay? It may overlap here and there, okay? But the two ideas are conceptually different, okay? When I say legal damage, I'm not saying physical damage or, actual damage. It's merely a legal damage, okay? A damage under the law, okay? So legal damage is not the same as actual damage or actual physical damage or, anything of that sort. It does not have to be, okay? legal damage conceptually is a little different from actual damage. We will see in one of the maxim or two of the maxims that we are going to discuss in a while. So yes, so every invasion of a plaintiff's right or unauthorized interference with the property, so any right that you have or any interference with your property of the sort that we just discussed, will lead to what we just called as legal damage, So when you suffer a legal damage, you do not have to suffer actual damage, So for example, someone trespasses your property. Your property may not have suffered any damage, any harm, actual harm, But the fact that someone interfered, entered your property, trespassed into your property, is sufficient to lead to legal damage, And even though you have not suffered, you have a remedy under the law. So have you understood the basic idea here? Why I said that legal damage is not the same thing as actual damage? You understood?
Yes, sir.
Okay. Very simple. So this idea, this separation between legal damage and actual damage leads, gives us to interesting maxims. Remember this. You probably already know about it if you have prepared for class. I don't know if you're required to, study all these maxims anymore. So, sorry. Hello. मैं तो क्लास ले रहा हूँ सर अभी मैं आ जाऊँगा सर आपको वहाँ पे So yes, so two maxims. The first one is Injuria sine damnum. I will type it. See, if you don't hear me clearly, I will type it here. So the first one is Injuria sine damnum. The other one is damnum sine injuria. So do you guys see it? I just typed it there. So these two, Latin maxims you need to know. One is injuria sine damnum. The other one is damnum sine injuria. So what do they mean? Let's look at the first one then. The first one says injuria sine damnum. So it essentially says, in simplest of words, that you have suffered legal damage, but you have not suffered actual damage. So you have suffered legal injury. The more use of the term here, you have suffered legal injury, but you have not suffered actual damage. So even if that is the case, because your private right has been interfered or invaded, you have a remedy under the law. So what does it say? It says there must be an infringement of a right, for a cause of action to arise, there must be an infringement of a right, The mere infringement of a right is actionable under the law, That's it. That's sufficient. We don't need anything more. But yes, of course, if you have not suffered anything substantial, what damages will be provided to you, that will definitely be less. But whatever token damages you are provided with by the court will still be provided to you. No matter whether you have suffered actual damage or not. So that's the essence of this maxim. But if you have suffered actual damage, in that case, yes, you will be given more compensation by the court. The court will determine in the light of the facts and circumstances. But even if you haven't suffered any actual harm, actual damage, the mere infringement of a right is enough. That leads to a actionable cause here. So if there is an infringement of a legal right, without causing actual harm, loss or damage to the plaintiff, the injury that you suffer here is legal injury, although you have not suffered actual injury. But quite often we know that, legal injury is also associated with actual injury. So I'm not saying that the court will not look at, actual injury, But there has to be first requirement is that there has to be a legal injury, So That's essentially the meaning of this maxim, that you suffer injuria, which is a legal a damage, okay, legal injury that you suffer, for which there is legal damage, okay, without damnum. Damnum means actual damage here, okay. So what does injuria means? Okay, injuria means unauthorized interference with general private right conferred by law on the plaintiff. Okay, so if you have a general private right conferred by the law on you, any interference, okay, with that will lead to injuria. Okay, it could be in the form of an act, or it could be in the form of an omission. We will discuss those in greater detail later on. Okay, now here's the thing. Okay, there are some torts. Okay, there are some torts that require presence of malice, intention, etc. Okay, but in most others, okay, there is no necessity of malice or willfulness. Okay, so it need not be deliberate. Okay, it could be indeliberate. Okay, but that's not really necessary component here, except for those specific ones in which it is necessary. Okay, I'll tell you what those are later on. Okay, so for example, malicious prosecution is a tort. Okay, so the name itself says that malice has to be. Malice means ill will. Okay, it has to be present. But in others, so for example, you trespassed into someone's property, you caused some kind of so for example, you planted a tree, the root goes under the the wall, and suppose it's a poisonous tree you have planted, and there's from the root that has gone across to the land of your neighbor, another tree comes up, and then his pet eats it and then dies. Okay, situation like that, you probably have never thought imagined that something like that will happen. You had no ill will here, okay, but some harm has been caused to others. So whether you had that malice or not is not necessary. Whether you willfully did it or not is not necessary. However, there are exceptional cases in which it is in fact necessary. So your act could be accidental as well. Okay, does not matter. Okay, if the plaintiff here has suffered an injury, then yes, there is a cause of action here, and that person will be provided with legal damages. Okay, so in case of injuria, the plaintiff does not need to prove any spatial damage, but if it has happened, then of course the plaintiff will claim that. But bare minimum, okay, there is no necessity of proving any spatial damage. Mere legal injuria will suffice. Okay, so in such case, if one has suffered, as I told you, actual damage, then the court will provide more compensation. But even if one has not suffered anything substantial, but a legal injury has happened, the court has to provide token or nominal damages. Okay, so one very important case in this respect is by the name Ashby versus White. Okay, I'll just type it here. This is a very important case. Okay, so remember this forever. We also have a similar case in India, Bhim versus State of J&K. Okay, you will study that in constitutional law later on. But let's look at this case here. Okay, Ashby versus White. Okay, so in this particular case, what had happened was that the plaintiff was prevented by the returning officer, okay, during election from exercising her right to vote. Okay, so she had a right to vote. She was prevented from exercising that right by the returning officer. Subsequently in the election, the person who the plaintiff would have voted for won nonetheless. Okay, so in such case, even though the plaintiff here, okay, didn't suffer anything substantial, okay, still her claim was allowed by the court. Okay, so here's an interesting quote by Lord Holt CJ. Okay, so essentially this surmises the maxim that I just told you about. Okay, so Lord Holt CJ says, okay, every injury imports a damage. Okay, so every injury imports a damage, though it does not cost the party one farthing. Okay, so some money. It does not cost the party any money. Okay, and it is impossible to prove the contrary. Okay, for a damage is not merely pecuniary, but and injury imports damage. When a man is thereby hindered of his right, as in an action for slanderous words, okay, though a man does not lose a penny by reason of speaking of them, yet he shall have an action. Okay. Further says, so if a man gives another a cuff on his ear, though it costs him nothing, not so much as a little diachylon, okay, plaster basically, yet he shall have his action. So a man shall have an action against another for riding over his ground, though it does not damage, for it is an invasion of his property, and the other has no right to come here. So you understand, okay, that from this quote, okay, I'm not going to type it here, but you will easily find this, okay. If you just Google search it, okay, you will find it. So what?
Do we write it?
Yes.
Sir, do we have to write this quote also?
No. I was just reading out something to you. So now, just let me give you one or two examples from that quote itself. Okay. So he says that someone comes and cuffs in your ear. Okay. You may not have suffered anything. Do you understand? You may not have suffered anything. Okay. Someone probably, so for example, someone tried to punch you. The person didn't really hit you. So you have not suffered anything physically. Okay. But your right has nonetheless been infringed. Okay. So even though you have not suffered actual damage, but you have suffered injuria. Okay. Because you have a right. Okay. Which has been infringed. That's sufficient. So someone rides over your property. You may not have suffered anything, in substance. But the fact that someone rode over your property is enough to lead to what we call as injuria here. Now, here's something that I need to tell you at this stage, okay? What we see here, the level of sophistication, refinement, and of the law, okay? And also the kind of individuality, okay? That we see here, protection of individuality, is a special feature of Western, legal systems. It's a different thing altogether. But we live in a society where people do, walk across our land without seeking any permission. And if we were to initiate litigation in the court for every such infraction, the court, which is already overburdened, will come to a screeching halt. I mean, it won't be able to function in any way. So, yes, that's what I said, okay? But whether it's a good thing or a bad thing, okay, being litigious is a good thing or a bad thing, I'm not commenting on that, okay, because that's not subject to this discussion that we are having, okay. But I think at the same time that, individual rights, okay, your private rights should be respected, okay, and our legal system should become efficient enough to be able to protect all your private rights, okay. Someone tries to threaten you, someone interferes with your property, someone, plays music, loud music, if there is a, marriage party next to your house, and there'll be, loud music throughout the night, okay. So all these things do happen, okay. What can you do about it? Not much really happen, okay. So I think it is important that, legal system becomes more efficient and more of your private rights are in fact protected, okay. But at the same time, a word of caution, okay, quite often the same could be exploited by those who are in positions of power and then, claim protection. So, corporations could also use things like this, okay. So you have to think about it. You have to think about it in terms of some kind of balance between the two extremes, okay. So I hope this is clear, okay. The first maxim, I hope this is clear. Is it clear? Okay.
Yes, sir.
Then let's look at the other maxim, okay. It's kind of opposite to the first one, okay. So the second one is says damnum sine injuria. So you have suffered actual harm, okay. You have suffered actual damages, okay. But you have not suffered any injuria. So there is no cause of action. So you will not get any damages. So this is the other situation, okay. So you will be wondering, how on earth is that possible, okay? How is it possible that I suffer, actual harm, actual damage, but then I have not suffered any legal injury. How is that possible? So that happens, okay? So if that happens, the maxim says that you do not have a cause of action. So you will not be entitled to any damages, okay? So that's the second maxim, okay? So let me give you an example of how that could happen. So for example, you open a shop, okay, at a nice location, okay? And then what happens is that you see many customers start coming to your shop, okay? And your friend notices that, okay, my friend has opened this shop and he's making lots of money, okay, lots of customers coming there. So what he does is that right next to your shop, he opens another shop, okay, and the same stuff's available there. So what happens now? Some people, okay, start going there, okay. So that definitely affects the profit that you are making from your business, from your shop, okay. So you have suffered, damages. You have suffered, some kind of harm, okay. But then, has any legal right that belong to you have been, harmed or affected here? What do you think? Any legal right? No legal right has been, affected, okay. So in situation like this, okay, you see that you have suffered actual harm, okay. Because of the opening of the shop, your profit has gone down, your earnings have gone down, but then you do not have a cause of action because the other person also has as much liberty to open his own shop, okay. So that's the application of the second maxim, okay. So we have some interesting cases though, okay. So remember these cases, okay. The first case is very famous case by the name Gloucester Grammar School case. I'll just type it here. Okay, so the first case is Gloucester Grammar School case, okay. So in this case, what had happened was that there was a grammar school, okay, Gloucester Grammar School, okay. So there were two masters, okay. They brought an action against another, master, okay. Why? So earlier the master used to, the third master used to work in the same school, okay. But something happened between them, so that guy left and he opened another school, nearby, okay. Now he was a really good teacher, okay. So many of his former pupils left that, grammar school and joined the newly opened school, okay. So, the claim, suit was brought against this master, okay, who had opened the subsequent, school, leading to, lowering of income of the first school, okay. So what was decided in this particular case? It was decided that if an act or omission cause injury to another, but no legal right is infringed, okay, no action will lie, it being damnum sine injuria. So even though in this particular case an act or an omission, okay, causes injury to another person, okay, causes, here I'm not using the word injury in the legal sense, okay, I'm using it in the actual sense, okay, it has caused actual injury to you, but no legal right has been infringed, okay, no action will lie, it being damnum sine injuria. So have you understood this maxim?
So,
Yes?
So is it similar to the movie Super 30, right?
Well, come to you. Well, let me hear this guy first. Okay, Barse.
So the thing is, in your argument, in the previous argument of the shop, don't I have a right against unfair trade practices?
So what will be the unfair trade here according to you?
So at the top of my head, like if someone is opening a shop right to me and is selling the same products as me, he is basically unfair competition.
No, it is not. In fact, capitalism thrives on this idea. So I'm talking about, again, political theory, political philosophy here. Let me tell you. What's the idea of capitalism? I'm not saying that capitalism is the justification, okay? So here's the idea. If you are the only shopkeeper somewhere, you will charge as much as you want because people do not have other options, okay? Someone else opens a shop next to you. Now you have to do competitive pricing, okay? Who gets the benefit? The people who buy. So I think it is better thing, okay, than only one shop. So Unfair trade practices are completely different. Okay, so monopoly would in fact be an unfair trade. Okay, monopoly in a business would in fact be an unfair trade practice. Okay.
So I won't count unfair trade practices in legal right.
No, this is clearly the example that I gave you is clearly not a case of unfair trade. Okay, you are not doing adulterating any substance. Okay, you are not doing anything of that sort. I'm not saying that the other person opened the shop and started selling fake stuff or spurious stuff. Okay, or adulterated stuff. No, those will be the problem that you have just suggested. Okay. He merely opened another shop. Okay, suppose, let me give you this. Okay, you purchased a piece of land, you built a shop, you stocked stuff there, and you've started selling that. I buy the adjacent piece of land next to you, legally valid. I open a new shop, legally valid, and then I start selling the same stuff. Where is the unfair trade? There is none. Okay. So yes, Samridhi, you had a question as well. I'll come to you. Let me answer Samridhi then.
Asking whether it is the same case, a similar case as that of Super 30, right?
I do not know much about Super 30, so would you like to tell us what it is all about?
So it's a movie based on a real person known as Anand Kumar.
Okay.
And
okay, so this IIT fellow.
Yes, sir. Yes.
Okay. What happened there? I don't know.
So he was basically teaching in an elite coaching institute, and then he saw the condition of the poor people who could not afford such heavy coaching fees and could not hence study. So he opened up a private free coaching for those who were underprivileged.
Okay.
So that was the story, and the competition, many students in his college, I would say, started complaining that we'll not study if Anand Kumar does not teaches us. He's our star teacher. So that was the same story, and a lot of legal issues also occurred there, and he was attacked quite a few times, and after it, he had a batch of 30 students.
Okay.
Hence the name Super 30.
Okay. So since I don't know the exact legal issue here, so I wouldn't be able to comment on that. But if it is of this nature, okay, then maybe it is applicable here. Okay, but the story seems very interesting. So you see, yes, Arnab or someone else who wanted
yes,
to
sir,
yes. Biswajit, Arnab, wait, I think Biswajit first, then I will come to you. Yes, Biswajit.
Sir, you have said that a shop which opened in front of the shop, it is purely legal or fair. Yes, I also believe that, sir, it is purely legal and free. But sir, why government come with so many laws that restrict some type of shops which should not open in the particular area, like commercial area, defense area? Then why?
So see, I'm not going into I wouldn't comment on whether government is justified in, for example, saying that alcohol shop should not be within 500 meters of,
Yes, sir.
Okay, something like that. I wouldn't go into all those questions. If you were to ask me in a different class, okay, whether it is justifiable or not, I will have a different answer to that. But for this subject, my concern is merely this, okay? So, for example, in this particular case, if there was already a prohibition on the part of the government that in so-and-so locality you cannot open shop and sell so-and-so item, but you nonetheless open the shop as against the law which has been created by the government prohibiting selling certain stuff, but you do it, your act is already in violation of a law. So you do not have a right there. You do not have a liberty to open the shop there, okay, because the law already prohibits sale. The case of legality that I was talking about here, I was talking about it only assuming that there was no such restriction imposed, okay? But had there been any such restrictions imposed, then you do not have a private right. Got the idea?
Actually, sir, yes, sir, it is true. But, sir, if you see in India, there are so many laws, like in Bihar, there is liquor ban. In other states, there is no ban on any liquors, and
yeah, so
you
have Gujarat as well.
Justifiable that some states are follow this type of rules and some type of follow this type of
but
rules.
see, on those things I have to answer from policy perspective or from moral perspective, etc., etc. I will not.
Okay.
Do you
Thank
understand?
You, sir.
Okay, I
understand.
will not address those questions here. Maybe in jurisprudence we will talk about those, or any other subjects I'll talk about that. But what I can tell you, okay, just off the top, okay, not related to the topic, is that you see, it depends, okay. So some believe that there should be regulation, others believe that there should not be regulation, okay. Now, when you talk about liquor, okay, you see, I have heard from my friends, okay, just as a matter of joke here, okay, that in those states where it has been, prohibited, you can get it much more easily there, okay, than in states, okay, where it is legal, okay. So I don't know what's the truth, okay, but that's what they say. I never tried that, okay. I didn't break any law, so I wouldn't know, but it's a hearsay. But, jokes aside, the thing is this, that you nonetheless need regulation. So, for example, this is your university, okay, and you have not yet come here. When you come here, you will see that there is a brick kiln next to it, okay, old, brick kiln just adjacent to your university campus. That is not functional, okay. Suppose tomorrow the person who owns it starts, making brick in that, in his factory. What will be the outcome? There will be severe pollution, okay, and that will affect you. So we have regulations, okay, we have laws, we have regulations, rules that prohibit certain activities, and that is necessary. Got the idea? That is necessary. So I'm not going to go into any more comment on that. So for example, we cannot allow everyone to make guns, okay. So even when it comes to liquor, okay, you hear so many people who die from, drinking hooch, okay. So many things happen. So you do need regulation, okay. But quite often, let me also tell you that over-regulation also leads to many problems, okay. Over-regulation also leads to problems. So for example, betting, when it is prohibited, IPL mein kya ghotala hota hai. Everywhere it happens, okay. So, but then let me tell you, those are not related to the subject here. So when I upload it, I have to cut this portion. So anyway, that's it for today. So tomorrow, I think in the next class, we have few more cases that we will discuss, and then, okay? I have one more question, I think. Arnav wanted to say something. Yes.
Yes, sir. Am I audible, sir?
Yes, you are clearly audible.
So suppose like India has not signed the free trade agreement with the Asia, I think China and Japan and all.
Okay.
They say they will dump their product in our country.
Okay.
So what is the difference that it is Defendant sign Injuria?
I don't know how to relate that, okay, but so for example, dumping is a different issue altogether, okay. You have anti-dumping laws, that's a different issue altogether, okay. So let me try and relate. How do I relate? So if you're saying that there is damage without injury, okay, then what are you suggesting? That there is in fact...
Can I give an example regarding this?
So for example, let me tell you, if there is a law that says that, such practices should not happen, okay. But before I comment on that, let me tell you, there is a matter of sovereign immunity here. And I have not, so these are matters between two sovereign countries, if I understood it correctly. When you say China, I'm not sure if you're referring to individual party or the China as a whole. Okay.
So can I give an example from my side?
Yes, give me.
Sir, suppose I am Starbucks owner and I am...
Sorry. Again, repeat it.
So suppose I am Starbucks owner,
okay,
and I am charging 1,000 rupees per coffee.
Okay.
Sir, you came to my locality and open a cafeteria, and you have the backing Chinese company, and you start selling same coffee at 10 rupees.
Okay.
So will that be damnance and injury? In that case, if I file a case...
Yes, let me tell you this, okay. So whether the guy who's selling, cheap China product, okay, has it been done legally or illegally?
So, like importing goods from other country?
No, importing goods is not illegal. If it is allowed, okay. But if it is illegal, then you are breaking law, then you do not have certain other rights, okay. But the question, my question is, question here is much more simple. Okay, is there any prohibition on opening a shop? Okay,
No, sir.
selling. So if there is none, then you have not caused any harm. Okay, you have not caused any legal injury. What you have done is legal, and if you have done it legally, then of course it will be the case of damnum sine injuria, and that in fact happens. You know that. So for example, Apple. Okay, so you have Tesla car, you have Apple phone. All these things are there. Okay, very costly. You have to shell out 70,000-80,000 today. These days, the 1 lakh and more. Okay, that's happening. But then Xiaomi comes and sells cheap stuff. Okay, forget about Xiaomi. There could be better product. Okay, better company who would sell stuff which are of competitive price. Okay, so person like me, okay, making little money, for me that will be more affordable. Okay, so now can Apple say that okay, this is a case of actual harm? No, it is not. If this company is importing the stuff legally and selling them legally, it is not a case of injuria. It is a clear case of damnum sine injuria. Okay. Any more question?
No, sir.
Okay, so it has to be legal. Okay, it cannot be illegal. If it is illegal, then you do not have a right already. Okay.
Sir, I have a small question.
Yes. Ayush.
Sir, if someone opens a shop which is very similar, which has a similar name and it is selling similar products,
Okay.
what happens?
So
Like
see,
the customer is getting
I think
confused.
you are referring to certain intellectual property issue here, huh? Trademarks.
Yes,
So those will be dealt with in your IPR classes. Okay. Now the shop itself is not a problem, but for example, McDonald's, for example, they have a certain brand, isn't it? If you go to Hyderabad, there is a restaurant by the name called Bawarchi. They sell biryani, and there is also another. Okay. Now there are many cheap riff-offs of that thing. Okay, that brand. Okay, in Hyderabad itself. Okay. Now it depends. Okay, it depends. Okay. If there is a violation of trademark, etc., then you have remedy under the said law. Okay, you have remedy under the said law. Now, if you do not have that, okay, if you sell something really good and someone who comes up and constructs an exact same shop, sells the same stuff, okay, but which is not a violation of one of these laws that I have just mentioned, okay, in such case, I don't see there being any problem. Do you understand?